Hello, I am Ketan from 192 Consulting. In the series of dealing with succession certificate, legal heirship certificate, in this corporate knowledge feed video, we are going to discuss about the exact procedure of how to obtain the succession certificate. Many a times, investors face this problem while they approach the courts to obtain the succession certificate. So we have come up with this video in which we will discuss and we will try to elaborate how a succession certificate is obtained and what are the modalities of it and what are the points those are required to be kept in mind while obtaining the succession certificate, right from making application to the court issuing that certificate and then going ahead. So what actually succession certificate is, that when the original investor is deceased, there is no will, there is no order of administration to that property, then in that case, and most importantly, the value of the shares is exceeding rupees 5 lakhs. So if all these conditions are met, then a person is going to require a succession certificate. Now, where can a person get a succession certificate? It can be obtained from the court of appropriate jurisdiction. Now, let us identify or let us dive deep into what is the jurisdiction of the court to which the application for succession certificate has to be made, or succession application has to be made. So first of all, identification of the jurisdiction of the court. There are two primary points to it. One is the place where the death has occurred. So this is the very simple principle where the application or where the succession application has to be made. If the death of the person has occurred in a particular city, then the court having jurisdiction over that place should have the right or should be entitled to adjudicate the matter of that succession certificate. Now let us contemplate or let us consider a case wherein a person has deceased in a particular city but is not a resident of that city. He might have traveled to another city for a particular time and then expired in that city while he is the resident, or he has been the permanent resident of a different area. Then in that case, conflict of jurisdiction arises over here. Then in that case, the city wherein the person was permanently residing or the court having that jurisdiction will be entitled to adjudicate that matter. So the provisions of Civil Procedure Code, the provisions of Limitation Act, and the provisions of Investor Education and Protection Fund Authority rules will come into play while determining the jurisdiction of the court. After having determined the court jurisdiction, the next thing that person has to do is to make a succession application. Now, how a succession application has to be built? There are three important parts of these things. First of all, the details of the legal heirs or the claimants who are making the application. Their relationship with the original property holder has to be established in the succession application. Point number two, a brief information of the person who has deceased, of the original holder of the shares in this case, I would say. And thirdly, the details of the property. Investors usually go wrong in part 3. So they'll mention the details of the legal heirs, they'll mention the details of the person who was the holder of the property during his lifetime, but the details of the property usually are not mentioned in detail, and this is exactly what is required. So it is very important for that person to mention the following details if the property which is being claimed are the shares of the company. So what are the details that the person has to mention in the succession application? First, the name of the deceased holder. Secondly, the folio number. Third, the distinctive number of shares. Fourth, share certificate number. And fifth, the number of shares. Without this, neither the court will issue the succession certificate nor the company and RTA will accept that succession certificate. Now, let us address one more complexity into this. What if the person is aware of the claim value and approaches the court for the succession certificate but is unaware about all these details which has to be mentioned or which have to be mentioned into the succession application, and all these details are not known because the person doesn't hold share certificate or the share certificate has been misplaced? In that case, details of holdings have to be obtained from the company or RTA. Now, If the share certificates are not there, then the details have to be obtained, and all these details have to be factored in the succession application. And only after drafting this succession application very carefully, only after that the application can be made to the court. The court authorities will vet that application, and then it will accept that application only if it is correct in all respects. So that's one more thing about the succession application. Going ahead, the verification of the document stage comes in after the succession application is done. The person who has made the application for obtaining the succession certificate to the court of appropriate jurisdiction will have to produce all the documents in originals to the court, and the court authorities will verify all those documents before proceeding with the matter. Now, suppose if the share certificates are not there, then the original documents received from the company can also be shown to the court, and the court authorities will accept those documents if they are satisfied that the case is genuine and the person who is producing those documents in front of the court has got the genuine claim over the title. After having verifying these documents, the court will put the matter for hearing. So in the hearing, the court will hear out the applicant and then issue an order, citation and publication of the public notice. Now this public notice should contain all the details regarding the shares, all the details regarding the shares or for which the succession certificate is sought. Then this public notice has to be given in the newspaper which is in the vernacular language of the state where the person is residing or person used to be residing at the time of his death, and secondly one English newspaper having the countrywide circulation. Usually the time period for this public notice is 30 days or 1 month. So 30 working days is something that we will refer to. So usually the public notice is given for 30 days. Any person or any entity claiming stake to the shares of any entity claiming stake to those shares shall raise his or her objection within this time period of 30 days. And if there is no objection within this time period, then again in the next court hearing that an affidavit should be filed that the public notice was issued in the newspapers having wide circulations in vernacular language as well as one English daily having countrywide circulation, and there were no objections to it. After the court is satisfied, it will call upon all the legal heirs mentioned in the succession application for the hearing, and the court will ask them certain questions about the details of the properties, and only after the court is satisfied that these legal heirs mentioned in the succession application are the rightful persons claiming stake to the property and there is no objection to it, then the court will issue the succession certificate. I'll appeal to the viewers of this video to adhere to these points while or keeping these points in mind while undergoing the procedure of obtaining the succession certificate from the court, because that succession certificate is going to give you the unencumbered right over those shares, and based on that succession certificate the investors can apply to the RTAs and the companies for the entitlement letter. Obtaining of the succession certificate is a very critical stage in the entire reclaiming procedure, because it in itself tells that the claims at stake are very high. Secondly, the person who is the original holder of that claim is deceased. So it gives rise to the complexities. And if something goes wrong in obtaining the succession certificate, it will have an adverse effect on the entire reclaiming procedure. As I've already mentioned, the entire procedure normally takes 8 to 10 months. The investors should be psychologically prepared for this time, for this time to be factored in the entire reclaiming procedure. We have discussed about the timeline for reclaiming procedure in one of our earlier videos. Now referring back to that video, in the cases or the claims where succession certificate is required, additional 8 to 10 months should be factored in. Plus, these 8 to 10 months is a ballpark figure or is a ballpark number which totally depends upon a lot of other factors such as the court, the case load in the court, the dates that the court assigns, and the complexities in the succession application. So this timeline may vary, but in a normal case, it is adjudicated in and around 8 to 10 months. Should you have any query relating to the procedure for obtaining of the succession certificate, viewers or investors are welcome to reach out to us. You may reach out to us by marking your comment in the comment section of this video, or you may also reach out to us by writing an email on info@192.in. We will be all the more happy to help. Till then, this is Ketan signing off. Thank you very much.